Finley said it better than I could just sit down right now. That's a fantastic introduction, right? But I did like, I did like you said it was fraud. I thought you said fraud there for a minute. I said, now you're talking. Now you're in my line of business. Anyway, good morning to everybody. I see a lot of friendly faces and familiar faces from yesterday. Thank you for returning. I really appreciate it. We're going to change gears a lot. And for those of you guys who didn't hear me speak yesterday, I only talk on topics that we actually handle on a day in and day out basis in the office. So I always kind of rip from the headlines. Here's what we're doing in the office. Here's what the IRS is attacking. And here's what I'm here to speak about today. And that is the limited partner exception to SECA taxes. I assume that most people deal with this on a regular basis. Yes, I see lots of nodding heads. I'm used to saying this, by the way, like talking to myself for two reasons. I'm not crazy. There are two reasons why this happens. Number one, I often speak and they're doing it on video or recording as well. And they always want you to say, make sure that people can understand what's going on, why there's a pause or whatnot. And secondarily, if you go to court a lot, you'll start figuring out that if it doesn't go in the microphone, right, it doesn't exist. So you're often narrating all the time, so it goes into the court record. But anyway, good morning. Thank you for coming. Let's talk about SECA taxes. What have partnerships done wrong? Profound question for 8:30 on a Monday morning. Well, the IRS says there's a lot of people that are inappropriately treating partners as limited partners, and they're doing so in order to avoid the 15.3% SECA taxes. What is this all about? Well, we're going to talk about today, and I mentioned some people when we were out having drinks yesterday afternoon. I'm going to be talking, and don't deflate yet, but I'm going to be talking about the history going back from at least 1977 until today. It's not going to be a boring history lesson. There'll be some comments and other things going on, but you have to understand what has happened from then until today. If you do not, you can't really profoundly understand what the disputes are about with the IRS and why they're happening and why it's, frankly, I think I put down here, chaos. Now, that might be hyperbole. It may not be hyperbole, but we've had basically government inaction in this area since 1977, and that's why we are where we are today. You guys do understand. I mean, I don't want to give it away before the presentation, but you guys know that the law hasn't changed and there's been no regulation since 1977 in this area. That's why things have changed a little bit since 1977. I remember back riding like a Schwinn bicycle with a banana seat in 1977, and we're still using the same law that we have back then. All right, let's get to it. Overview of SECA taxes. Why do I have this? Well, as I mentioned to many people, I go out and speak from groups of massive size to very small size, sophisticated tax practitioners and otherwise, and so we have to be courteous to everybody and get them up to speed. So here's the basics, and it's just one quick slide. Everyone knows about employment taxes. When we're talking about employees, quite straightforward, we're talking about FICA. When you've got sole proprietors, independent contractors, and partners, right, SECA substitutes FICA. That's the entire lesson we're talking about here today. They're like, oh, thank goodness. And the rate, and I always check because I think it does change, but currently it's at 15.3%. Am I? Okay, good. And I would tell everyone, I'm just a tax defense attorney. I'm not the guy who puts it on the tax return. So if you're talking about that level, I have to work with and depend on you all. And also, we're going to talk a whole lot today about the exception under 1402A3. All right, so let's get to the key rule, and there's not much. I usually try not to mention sections too much. It's boring to people and boring to me as well. But let's look at it. It says the key term here is net earnings from self-employment. That's what's subject to the 15.3%. And what that normally means is gross income derived by an individual from any trade or business minus certain business-related deductions and the distributor's share from any partnership in which he is a partner. That is the general rule. 1403A13 excludes from that definition of net earnings from self-employment and thus from SECA taxes the distributor's share to any quote-unquote limited partner as a limited partner other than certain guaranteed payments. That's the whole frame up, and those two, both section and exception there too, have set off a whole stream of litigation that's already going on and probably go on for the next 5 years. As I promised, I call this section the long road to uncertainty. Again, why I'm telling you is not to be dogmatic about it. It's because you'll see at the very, very end when we're talking about all the current cases that are in tax court, and there are a bunch, and there's already some in the federal courts of appeals. We need to understand the long road to uncertainty in order to figure out what's happening in the courts today. All right, that's kind of like the slide I had before, but anyway, as I said, what have the partnerships done wrong? Right? If you ask me, And again, if you guys heard me speak yesterday, I make some comments that I think are funny. It's more my personality. But what are the partners? What are the partnerships done wrong? Well, in my opinion, most of the time, nothing. And certainly on the defense side, we would say nothing. The IRS, on the other hand, says no. A lot of these people that are being treated as limited partners should not be treated as limited partners. Now I know, and we're going to get to some of the cases. You may say, well, I mean, it's only 15.3%. How much money are we really talking about? Well, let me tell you, in some of these cases that are in court now, they're talking about trying to put SECA taxes on amounts up to $80 million. So we're talking about very, very big numbers, and year after year after year after year. So we have a lot of the sophisticated multi-tiered partnerships coming out of New York, and it's a massive amount of money. So it goes from the very small to the very large, and that's why I like talking to every single group, because whether it is a huge case or a small case, you guys confront the same kind of issues, right? I would assume, and whether you admit it or not, I assume you have these kind of discussions with, I already see the not, yes, I know it's coming. Yes, you have this discussion with individuals, right, all the time. How are they going to be treated as limited partners or not? What the risk is, what the cost is? Yes? Okay, good. Well, I said that's why it goes big to small. It really doesn't matter. It's all relative. Anyway, the taxpayer's position is based on a law that was from 1977, and as I said in the introduction, there's really been no significant action by the Congress or the IRS since that time. Let's get to it. All right, it all starts. Settle in, guys. Settle in. This is going to be a long road that we're talking about. It started in 1977. Actually, it starts before that. Anyone who hasn't looked at the outline, does anyone know when they started the Social Security system here in the United States? Wow, you guys are very educated. Usually there's no hands that pop up. You know, some are already salivating, sleeping by now. But anyway, 1937 is when the Social Security system started. When it began, self-employed workers did not contribute to and were not eligible to receive benefits from the Social Security system, right, in 1937. This changed in 1950 when Congress introduced the SECA taxes, and at that point, again in 1950, distributed shares to all partners, both limited and general, were subject to SECA taxes initially. That's how it all began. 1937, 1950, it applied to everybody. Then in 1977, things changed. That's when Congress introduced, as I said before, 1402A13. That is the exception that we're talking about. It creates the exception for limited partners. And what did this say? Again, I promise not too much reading of code sections, but we have to read this one to make sure we're all on the same page, as the kids say. It says, there shall be excluded from the distributed share of any item of income or loss of a limited partner as such, and that phrase as such has led to lots of litigation, other than guaranteed payments described in section 707C to that partner for services actually rendered to or on behalf of the partnership, to the extent that those payments are established in the nature of remuneration for services. Holy cow, that's a mouthful, but that's the code section we're talking about. Generally, just shorten it down to the exception for limited partners. And I wasn't joking about that little phrase between commas that says, as such, right? There have been cases, and I've written lots of articles about what as such means, right? Does that mean in their role as limited partners? Does that mean it's crazy? Look, lawyers are crazy. That's just you already know this. I'm telling you the obvious, but there's lots of litigation based on that. All right. Now, you knew before when it started, right? The Social Security in 1937. For those of you who didn't read the outline, and I usually make the bad joke that most of you, I'm sure, read the outline last night. It's only funny because no one read my outline last night. I know that's true, right? They might hear this and say, okay, wow, he brought some new points to my attention. I'm going to go back and read this because I don't have to do research. It's all right here. And I do tell you guys, by the way, if you do see my outlines, it's not just the outline itself. I have footnotes for everything that I cite in the outline, and I leave that in by design. So if you guys are having a case, it's very easy. You just go back and say, oh, here it is. And I assure you those are accurate because we did lots of checking. These are not AI. And I know why it's not AI. You know how? Because I don't know how to use AI. So it's not AI. And I always make this, I tell people when I write a lot, this is a little off script, but when I send in articles all the time with editors I've been working with for years and years and years, they have a new like declaration I have to make. They're like, Hale, just tell us please that you wrote this and that no AI was used and whatever else. And I always write back the same thing. I've been writing the same kind of things in the same voice for like decades now. And oh, by the way, I don't even know how to use AI. So, and they just, after the first time I say that, they stop asking. But it's a new wave. You guys, I'm sure, have seen all those cases, right, where the lawyers are being sanctioned for. And by the way, it's not just private sector lawyers. it's government lawyers as well that are getting hit with these sanctions for just turning in briefs that have been written in whole or in part by AI. Have you guys been following this stuff? It's crazy. I think that in order to stop this, it's going to have to come to a point where they just rip somebody's license and takes it away altogether, right? And then people will stop using it. But anyway, back to the topic. You guys knew when Social Security was introduced in 1937. Do you guys know why the limited partner exception was introduced in 1977? This is fundamental. We got some cynicism up front. The congressman probably did it with vested interest, and that's usually a good answer. Absolutely true. Yes, I have a hand here toward the back.
They thought that it would be unfair for people, limited partners, because sometimes limited partners do actively participate in the business. They thought it'd be unfair for them to not receive Social Security benefits as they also get older.
Yeah, let's say partially right. Yeah, but you're right onto that. It was about, and I think you're both partially right. It was about manipulation and distortion, but not in the way that you think. So again, remember, we started out in 1950 and it said everybody was going to be subject to the SECA tax, the general and the limited partners. At the time, and again, I'm not making this up, by the way, this all comes from the legislative history. I've got it cited in here. You can read all about it. I didn't know this when we started this project, and I read the briefs filed with the court, and clearly most of the lawyers handling these cases don't know it either, and it's fundamental. It started because many workers, in particular government workers, were trying to become limited partners. They wanted to pay SECA taxes because they wanted, to your point, sir, they wanted to get the benefits of Social Security in the long run, right? So they would set up, they would go, and again, it's because they were at the time, I'm not an expert in how government workers have retirement, but at the time they weren't under the same system, Social Security, and they weren't getting the same benefits. And they said, hey, I really want this. So how do I do it? Well, people were going out and promoting to them that they could be involved in a partnership. They put in the minimum amount that they possibly had to get, and they got the amount of income they had to get per year, like $400, I mean, something very, very small back in the time. And that was enough to trigger the Social Security benefits. And as you guys know far better than I do, the way that those are rolled out, they favor disproportionately the lower income. So it made a lot of economic sense to voluntarily pay SECA taxes right at that period of time to get the long-term Social Security benefits. And you would say, well, what's the math on that? And the answer is, I don't know. If you know me, I'm not going to be in doing the math, but I will tell you, we talked about the current rate of 15.3%. I think back then it was like 2 point something percent. So if you look at it, you say, oh yeah, I'm happy to pay the 2.4% of SECA because I get all the Social Security benefits going forward. So ironically, maybe this isn't as enlightening to you as it was to me. I said, wow, I didn't know this, that promoters are out trying to get government workers. It would only be better if I saw IRS workers doing it. But anyway, a lot of government workers taking advantage of this system to try to become limited partners to take advantage of the Social Security system. That was the problem. And again, to your point, there's probably maybe someone was getting greased. I don't know. That does tend to happen. Anyway, that's what it was all about. And they said, hey, we can't have this happening. And you can imagine I can't imagine that this was a widespread problem, honestly, in the whole scheme of things. But they created the whole exception, right, under 1402A13, which has led to all this chaos for 50 years to solve this very, what I would call, narrow problem. So narrow problem, huge remedy that they tried to put into place in 1977. And had they kept up with the times, I don't think this would be problematic, but they have not kept up with the times. So that's the history of what it is, of why it was. And let me see if I can pull out anything. I've got a whole bunch of quotes because I find it very, very interesting. But probably the most interesting, and it comes up later into the cases, is when you read what Congress is saying and why. They said, hey, right, we've got to do something basically about this problem. And it's designed, it says, this is to exclude for Social Security coverage purposes only certain earnings which are basically of an investment nature, right? So that is the key about the investment nature versus making it on the sweat of your brow. So anyway, again, I find it fascinating. Trying to read the room here. You guys find it somewhat interesting, but not as fascinating as Hale does. All right, I get it. Move on. We're on to the next. You never know. It's like a comedian. You got to keep throwing stuff out there. Some land, some don't. It doesn't. Whatever. All right, I pointed out this issue, narrow problem, big fix, which has led us to where we are today. Let's go forward to 1994. So the timeline. Social Security 1937. Everyone was subject to it in 1950. they said, meaning Congress said, hey, guys, this is a problem. Some government workers, and I'm sure others, are just trying to game the system. I call it financial arbitrage, paying the SECA taxes voluntarily and inappropriately. Can you imagine people trying now these days to, hey, can I pay the 15.3%? No, we're doing everything possible not to pay the 15.3%, but that's what was happening back then. Fast forward, and I say that tongue in cheek, there was nothing fast about this happening. This was in 1994, so I don't know.
17.
Clearly, they picked up on my lack of mathematical skills. So 17 years, this will be great. You're going to keep score for me. I should, if I had a pen, I'd be writing this down so next time the presentation would be better. 1994, they introduced, they being this time the IRS, not Congress, but the IRS, introduced what I'm going to call the first proposed regulations. And all of these terms are designed to make it, you understand what I'm talking about. And secondarily, they're recurrent. So as we, if you make it awake until the end of this presentation, I'm going to be using some of the same phrases and terminology when we get there. So 1994, the Congress or IRS says, hey, we got to do something about this. We need some guidance. I mean, Congress only acted 17 years ago. We need to get some guidance out there by this period of time. So they come out with the first proposed regulations. And what did they say? Well, they said, number one, let's look at it. It said, a member, oh, and by the way, they only apply to, and think back, this is a long time ago, relatively speaking, they only applied to partnerships, right? Limited partnerships and limited liability companies. You can imagine how many different types of entities there are today, but at this time, these first proposed regs only applied specifically to limited partnerships and limited liability companies. And the IRS proposed the following. They said, well, here's who a member of an LLC is going to be treated as a quote unquote limited partner, meaning they could take advantage of this exception if they met two criteria. First, the member could not be a quote unquote manager of the LLC. Manager. And of course, guys, this is tax. Then we could talk for a day and a half about what manager meant and how many fights there were about it, but we're not going to do that, and I'm sure you're happy. Secondly, the pertinent entity, right, could have been formed as a limited partnership if it had wanted to instead of an LLC, and the member could have qualified as a limited partner instead of a member of an LLC. All right, that's what it was all about in the firm in terms of the first proposed regulations with the IRS. It also goes on to say that what they're really focused on is the federal level, not the state level. And of course, if it does pertain to you in a case you're handling, I've got more information about the definitions of manager, et cetera, in the following pages of the outline. So that's 1994. And if you guys saw the presentation yesterday, if you didn't, I'm sorry, that was rip-roaring fun yesterday afternoon. Maybe not. It was we learned something. We had a good time. It was a nice warm up into the drinks and the camaraderie later. But anyway, it was in 1994. But I talked a lot about in the presentation yesterday about the importance of the Administrative Procedures Act, right? The APA. And I'm sure if you have tax notes or checkpoint or whatever we all have, I have like 400 services, and I need that thing that they always advertise on the radio, like to shut off my subscriptions. I don't know. But anyway, they talk a lot about the APA, and we bring this up in many of our cases. But the notion of that is that if the IRS is going to pass or issue rules that are going to have legal effect, they have to comply with the APA. And that generally means to issue proposed regulations, get input from the public. And that's usually when they say, hey, send me in your comments. Let's have a hearing about this. Then they analyze or pretend to, read what you have to say and analyze it. And then they issue the final rules. That's simplifying what the APA requires the IRS to do. And they haven't always done that historically. Here, it actually worked, right? They put out the first proposed regulations in 1994. They got a heck of a lot of input from the outside. And again, if you guys are ever interested in that kind of stuff, I have copies of all the comments that come in because they're available to the public if you know how to get them. So I have that whole roster. So they got a lot of input from people, and the IRS actually listened to this, right? So kudos to the IRS. And they came out with what are called the second proposed regulations in 1997. And these are the most important, and these are going to run throughout even up to the litigation today. All right, what do the second proposed regulations say? Well, they're slightly different than the first ones in several different ways. First off, they said that these rules are not simply going to apply to limited partners, limited partnerships, and limited liability companies. Nope, let's make it broader than that. All right, so if you're following along the outline, it says they specifically or expressly apply to, and this is like alphabet soup. I read this and I just scratch my head. This is crazy. Limited partnerships, limited liability companies, limited liability partnerships, limited liability, limited partnerships, and other entities that have emerged since that period of time. I don't know how many L's you can put into an entity, but I've counted at least 3 on the last one, right? Limited liability, limited partnership. And every state's different and they have different rules and requirements, et cetera. And I think it's all, I don't want to say it's a race to the bottom, but as you guys know, all the states want people to form their entities in their states. So they form something that's very business friendly, and that's how you get all these iterations of what we have here today. Anyway, the point is IRS said, hey, this is a lot broader than limited partnerships and limited liability companies. Let's put the regulations that apply to all of these entities to make sure nothing escapes. And now they changed the definition. As we talked before, we talked about the concept of either being a manager and the fact that it could have been an LP instead of an LLC. Now they have different criteria. Here's what the IRS says. They changed the definition of limited partner. The second proposed regulation stated that an individual was presumed, right, legally presumed, to be a limited partner unless, there should be an easier way to write this than that, right? Anyway, a legal presumption unless, and here it is. It says he, I guess they were just being sexist at the time. I'm just going to go with he, not because it's me. This is the IRS's words, not mine. Anyway, he was personally liable for the debts or other claims against the partnership. So we're talking about liability here, right? Limited liability. Or he had the authority under state law to engage in contracts and otherwise bind the partnership, or he participated in the partnership's business for more than 500 hours during a year. All right? So you're going to say you're going to presume to be a limited partner unless one of these things occurs, to go quickly, right? You don't have limited liability, right? You're stuck with the debts of the entity. That makes sense. Number 2, you could actually go out and bind the entity. Or 3, you worked a lot for the entity, more than 500 hours. Now, if you hear this last criteria, and I do, because we do cases all over the board, if you start thinking, does that sound a lot like the standards for material participation under Section 469? Yes. He said close. I heard absolutely, Hale. That was a really insightful comment. Thank you. Thank you for that. The answer is yes. It sounds very much like the material participation standards. And that, again, I don't want to foreshadow too much, but this is going to be very important later on about whether the IRS agrees with or disagrees with using the cases in the 469 realm. Anyway, I point out the IRS came up with these rules. We didn't. So this is 1997, the second proposed regulations. Let me go on to tell you some more important things about these regulations. They contained a specific whole write-up about the concept of a service partnership, right? Service partners in service partnerships. And here's what it means. A service partner, this is not, too revealing. It says any partner who provided services either to the partnership or on behalf of the partnership's trade or business. Easy enough. Here, I find this terribly interesting, and maybe this is to your point about I always scratch my head and say, how did these people get stuck with this characterization? A service partnership was a partnership substantially of all of whose activities involved the performance of services in several fields. Are you ready? Where's Phyllis? She gave me the drum roll. I should have pulled this out. The drum roll. She sent it to me. Yeah, I didn't even get it in. I'm going to integrate it next time with a beep sound drum roll. Here it is. That's going to create increase the drama. It says in the fields of health, i.e., what? Doctors, nurses, and healthcare. 2, law, of course. Enough said. Engineering, architecture, accounting. We didn't leave everybody out. Consulting and I like this one. I always point it out because this is the head scratcher to me. I see where the other ones are. You're like, hey, this is a service partner. Lawyers, you're just providing legal services. You're providing accounting services. I get all it. You're performing a surgery. This all makes sense. But look who they put in there. Look at these bad characters. The actuarial scientists. These guys are tax cheaters galore. You know they are. Anyway, I read this. I tried to go back because you get my personality. I'm like, I got to find out more. Who suggested actuarial scientists are in this group with all these other ones, right? But no, I never found an answer to that. I think that's a riddle I'll probably die not solving right there, actuarial scientists. If anyone else has any insight, going back to 1997, let me know because I'd be very curious. I'd like to put it into the presentation. All right, so that's what happened as far as the second second proposed regulations. And again, getting to the idea of why they did it this way, right? right? They complied with the APA. That means that the IRS is going to explain to you why they did it a certain way so they don't run afoul of the APA. And here's what they said. They said a number of things, including, hey, guys, and again, they don't talk this way, I do. They said, hey, guys, we've got all these states out there. They have different rules for formation of entities, different rules, different standards, et cetera. And we need some conformity on the federal tax level. So with all these LLLPs, LLL, triple XPZs, whatever you have out there, we need to figure out a way for tax purposes to have some conformity. That's number one. So what the IRS has said then, and they say now, and I've highlighted it in the outline, they say for the reason that we, the IRS, created some quote unquote functional tests. I see it as kind of substance over form. You call them this, but in reality, here is what they're doing, right? That's how they looked at liability, looked at their authority, and looked at how many hours that they worked. They call those functional tests or a functional approach, okay? That was what they said in the regulations, and they will keep saying this in all the litigation several years later. And lastly, what they pointed out, and this becomes important in the current cases, they said, the characterization of a certain individual for state tax purposes as a limited partner is not determinative for federal tax purposes. So you can call them whatever you want under New York state law. That doesn't mean for federal SECA purposes, they are going to be limited partners. Sounds pretty basic, right? But when you go to court, one of the arguments about the lawyers always use is, wait, I set up I'm not picking on, I'm here in New York, so I'm picking on New York. But anyway, probably more often Delaware, Tennessee, Cayman Islands. I don't know. Where do people set up entities anymore? I'm not on the entity formation side. Delaware, Wyoming, Nevada. I'm sending your guys' names into the IRS right now. No, I do know that they're out in different places. We have, and I love to tell these stories because it's more entertaining than sometimes the law, but we have what's going on in Georgia. I don't know if you have it here. We have a huge amount of cars that are registered in Montana. Do you guys have that? They set up an LLC in Montana and then they buy their car under the LLC so they can avoid our state sales tax, which by the way, I don't even know what it is. Now, if you were doing this, I'm not telling people how to run. I'm a defense guy. I don't tell people how to run your business. I mean, that's fine. But I would think if you're going to do that, try not to get a Lamborghini. Yeah, because we have it all the time, right? They don't drive. Atlanta's got 400 lanes of traffic, right? So they don't drive it on regular days. They don't want to get hit by somebody. So you only see them on the weekend. Well, actually, you don't see them too much. You hear them. Right, running up, and there's always in packs. It used to be like motorcycles, now it's the luxury cars, and they're all running with Montana plates on it. And of course, not just Montana plates, but then they have some really, what they consider really, clever. I don't even give you an example right now, but something on the back, right, to even draw more attention to their vehicle as if they needed that. And then there was a big sting operation, everyone got in trouble. And wait, did I need more build up to that? There was a lot of stuff going on. Then a mere 45 years later, Georgia Department of Revenue figured it out. And then they said, you know what would be easy? I'll just go to the dealers that's selling them this car and basically get them to become informants. And you know what they did? They did. Didn't take a lot of pressure to say, hey, these customers that bought $200,000 cars from you, we're either going to put you in jail or give us their names. And then miraculously, they gave over the names. All right, back to this. Again, this wasn't really part of it, but just an example of the fact that state law purposes and federal law purposes are different. What happened? The IRS is making some progress, right? And if you guys have seen my last presentation, I'm not overly effusive and complimentary of the IRS in my normal day, but here it seemed like they were down the right path. It took them only, I thought you were going to help me out, 20 years since the time the law was passed, but they came up with some you're failing me. No, I'm on 20. I'm on 20 now at 1997. All right, so we're in 1997 still. So IRS was making these second proposed regulations. Fantastic. They had complied with the APA. We were ready to go. Everyone thought it was going to be finalized in short order. Oh, we're still waiting because they have not been finalized. So that was a long, dramatic pause. Anyway, and why, again, I find this so interesting. Maybe not you all, but I find it interesting and important to our litigation today. Why did it not get finalized? Because Congress said, you can't do that. That's my job, quote unquote. They didn't say that's my job. I made that up. All right. But anyway, here's what they did say. And I say in a demonstration of governmental gridlock, I mean, I thought you couldn't surpass it, but we have to this day. Anyway, as we were in furloughed, it says, in 1997, Congress said specifically, they put it in, and it was great. They put it into a law, and it was called the state, what was it called? The State of the Senate this is fantastic, or sense of the Senate, and they said, quote, no temporary or final regulation with respect to the definition of limited partner for purposes of this exception may be issued or effective before July 1st, 1998. What Congress said was, hey, IRS, we've seen your proposed regulations. We know what you're doing. Stop. Give us 18 months because we're Congress. We created this definition of limited partner. We're going to define the damn thing. Did not happen. Anyway, they said give them 18 months. It was a moratorium, only halt for 18 months. But I'm not, this is true. If you talk to the IRS today, they said, hey, I've tried to go up against the Congress before on this. I'm not going to spend all of this effort and do all of this stuff only to get it shot down by Congress. So basically, hell with them. We're just going to go litigate every case until they get this figured out. But it all started in 1997 when Congress said, does this look childish, right? Who's got the power? Who's going to do this? But really, it's all rooted back to now, what, 20, oh, you're going to help me out nonstop. Anyway, where we are today, back to 1997, a heck of a long time ago, 28 years ago. It all started 28 years ago with why we are where we are today. So Congress said we were going to do this, and they had some other funny comments about it, but it was really about the division of power, right? The branches, legislative, judicial, executive, and who was supposed to be doing what. And Congress thought it was going to be its job. It never happened. All right. Just because Congress didn't act, right, and just because the IRS had forestalled all of its actions, it doesn't mean that the public stopped, right? We're still out there doing what we're doing. You guys are doing tax returns every year. You're giving advice to people. I'm defending people when they get challenged by the IRS. So life goes on. And of course, they keep saying to the IRS and the Congress, hey guys, you might want to make some changes because this problem hasn't disappeared. In fact, with the increase of different types of entities out there and lack of information, I would argue that it's gotten worse, to use an adjective, as opposed to better. So you need to do something. And they've sent different proposals in over the course of time to Congress and to the IRS. And here's what they were. I put them into 3 different categories. Again, I really do. I joke, you guys know this, I joke around all the time. This is part of the presentation. It's fun, it makes it more entertaining, but I'm deadly serious about this stuff, and I'm deadly serious about litigation. And I do a lot of research on putting these together to save you some time. So here are the 3 different proposals. The first is, people say, wait, why don't we simply use or borrow from extensively the existing set of regulations and rules in cases that we have for the material participation standard under Section 469? Who's on board with that? Wow, I thought there'd be some more hands shooting. I'm like, oh yes, it's fairly established case law. I don't know. I mean, it's a great start. They've already worked very hard to put those together.
469 is being litigated.
Yeah, that is true, 469. But in difference, and we get to that, I don't think we're going to spend too much time because even for me, it's too tedious. But the IRS has acted very quickly in the 469 area. They have new definition. I mean, so they are changing that all the time. They're very focused on that. They don't have this kind of stalemate they have. But anyway, it was an idea. They said, look, we have got a whole extensive set of regulations under 469. We are changing these on a fairly regular basis. We've got lots of cases that have been litigated about this. And conceptually, right as we went back, don't make me go back to the earlier slides, right? But we said under the second proposed regulations, the last test was, did you work 500 or more hours for the partnership? So they were even hinting at that, right? That was the idea that people said, let's just be reasonable and go with that. Here was a second set of ideas that they had. It's less dramatic. I wish I could roll these out so I didn't, I could like a big reveal every time, but I promise with time, I will learn how to use Kava or whatever my little kid. It's embarrassing. My kids are 11 and 13 and they do better PowerPoints than I do, right? They roll them out. It's nuts. But I will violate some child labor laws and get a better presentation for you next time to roll this out. Anyway, the next one is the reasonable compensation standards, right? So he said, hey, why don't we use material participation under 469? If you don't like that, also, we've got a whole set of standards and case law and everything out with reasonable compensation. And you typically see that right in the corporation area, S Corp. We see those kind of cases all the time, right? What is reasonable? I don't know. You'll know it when you see it. What, you want me to deliver that? It was a delivery. It wasn't I just made that up. All right. We're going to go on. I'm going to note that down as maybe use that next time as a joke. All right. So they said maybe the reasonable compensation standard. And then here's the last one. And again, these are all inherently logical proposals to solve the mess that we're in now. Yes. Now you're getting on board with the cynicism. He's yelling out, Congress won't adopt them, the IRS won't either because of stalemate. But yes, these are all seem very logical to me. Material participation, perhaps we could use those rules. Reasonable compensation, perhaps we could use those rules. And then lastly, what they said is, hey, let's just come up with a safe harbor, right? This is not a revolutionary idea. You guys are all very familiar with the safe harbor, right? They come out with, let's say, some kind of tax credit. And then they say, okay, it's doing this, it's doing this. Let's just we're just going to issue a rev proc, guys, and basically say, if you do this or it's within this range, we're not going to, they don't say bust your chops, but in essence, we know what that means. We're not going to audit you or question you, et cetera. Inherently reasonable to come out with a safe harbor happens all the time. So people suggest, let's just come up with a safe harbor. And you would say, okay, well, what does that mean? Well, at the time, again, this is going back some years ago, they said, well, let's just divide up, and based on how much capital you put into the entity itself, right? You get so much out per year, and we're going to consider a percentage of that to be passive income, right? And a percentage off the sweat of your brow. So a portion, it's like a bifurcation, right? A portion subject to SECA, a portion not. And at the time they said, hey, your return on that capital investment would have been about 5.4%. That's what again, this was many, many years ago, not what it is today. I don't know. I don't do investments. What are people making now on their investments out there? I'm just looking for a new financial advisor. So when someone yells out like 10.5, I'll be like, yeah, I'm going to talk to you after this. I don't know what it is. But the point is, I'm hoping perhaps it's higher than that. But this was in 2004. All right. So where are we? I like to make sure that we're all with us and everyone's actually still awake. 1937, Social Security came into existence. 1950 said all partners, limited and general, were subject to this. 1977, Congress says, aha. They didn't say it. I said, aha, some people are cheating on this, and they are intentionally becoming limited partners solely for purposes of gaming the system and getting their Social Security benefits in the long run. 1994, this is by memory, and if I'm not right, I know you'll call me out. 1994, just a mere 17 years later, the IRS says, I'm going to put some meat on these bones. Let's get some first proposed regulations. They put them out. There were lots of comments about it. They actually read the comments and said, let me rethink this, and came out with the second proposed regulations in 1997. Everyone thought, all right, we're going to put these in final form and use these and let's go on. Congress came forward and said, nope, that's our job, not your job. Don't do anything for 18 months. And those 18 months have turned into that's my kind of math. You yelled out 67 years. That is accurate enough for Hale terms. Fantastic. 67 years. Then people said, wait a minute, we still have an ongoing problem. We need to get this solved, notwithstanding the stalemate between Congress and the IRS. So let's put a bunch of proposals out there all the time. And they fell into three major categories. That's where we are today. And we are, if you're thinking, oh my God, how much more of this road? Well, we're up to 2003. Up to 2003. Here we go. 2003. The IRS comes out in major conferences and they said, okay, hey guys, we know we never put in final form the second proposed regulations, right? With stifle it, the yawning, that's what happens when you come to one of my presentations and yawn blatantly, you're going to get called out. That's right, the authority, the definition, the number of hours, et cetera. And they said, hey, look, we didn't finalize those rules. They're still in proposed form. And we understand proposed rules have no legal authority, but we, the IRS, are going to respect those. If you respect them, we'll respect them. In fact, the quote was, if the taxpayer can you imagine they speak like this? If the taxpayer conforms to the latest set of proposed rules, we generally will not challenge what they do or don't do with regard to self-employment taxes. That's pretty clear, right? They're not finalized, but hell with Congress. We're just going to go with the proposed rules. I don't know how you say that, have it being legally authoritative, but anyway, that's what they said, and that's what people believed and went forward with in good faith. That's in 2003. So everyone was enlightened, right? That's what they were in 2003. Let's go forward. Now we're jumping. Okay, I jumped over a whole slide. Woo, all right, audible. Let's go forward. But I do go back to those later. You're not off the hook. We're going to go back to those cases later in the presentation. We've got another like 50, and Emily's going to call me out. She's going to make me go to the last minute. Anyway, at least 50 minutes until we finish this up. All right, the most famous case until recently, it was called Rankemeyer. Have you guys heard of Rankemeyer? Where's Shannon? Shannon, she probably got it tattooed on her. Put it on later. Ask her. She's got 60. She showed me. I was just talking to Shannon out on the breakfast this morning, and she had showed me that she had she's going to present later, right? She's got the tattoo on her arm that said 61A for gross income. It's fantastic. So anyway, maybe she's going to put Rankemeyer. If my wife would let me, I would do something in turn, but she doesn't let me. Anyway, we're on to Rankemeyer. This is from 2011, and why it's famous is because up until the last, let's say, year, it is the only case that had precedential value on this particular issue. Now, you may say, well, Hale, you're going to go through all of these chief counsel advisories, all of these tax TC memos, et cetera. Yes, I will. And those are all great. Not to bore you too much, but in my job, those don't mean, and this is technical, get ready, those don't mean squat. Those are not authoritative with the IRS or the other courts. There's a hierarchy to what you can depend on and what you can't depend on. So Rankemeyer was the only what we call TC opinion. And not to get too boring, what that really means, if you guys don't go to tax court regularly, but what it really means is a TC opinion, and all the judges look at all these. Do you guys know the levels of all the opinions out of the court? Yes? Okay, good. I don't need to go over, but there's several levels, the top being a TC, quote unquote, reviewed opinion, meaning not only was it a TC opinion, but all the judges weighed in on their opinion about this, and this is just below that, a TC opinion. So, unfortunately, there's two things that are unfortunate. Well, maybe three. I don't want to limit myself. Number one, it was about lawyers. Lawyers breaking the law. I mean, can you imagine? Number two, this law firm was based in Kansas, and if you guys read the bio or talked with me, I'm actually from Kansas. So this wasn't me, but it hurt, right? It hurt. And third, it was a bad outcome for the taxpayer. So for three different levels, this is not a good case, but I'm going to tell you about it anyway. Here are the basic facts. Let me wait. I've got too many here. Let me, here it is. I don't have my normal outline. I don't even have it highlighted. I'm just, well, no, I wrote it. So, I mean, I'm winging it, but it is, I'm not sticking to my normal methodical going through. Now I'm at Rankemeyer, and for those of you I know who are looking through the outline as we go through it and making notes, no one's doing that. All right. It's maybe someone, maybe it's their highlights and squares. Anyway, I'm on page, I don't know what you have, but mine is page 17. So we're probably in the same vicinity. But we're talking about Rankemeyer. Here's what it was. It was a law firm, and they formed under, I think, Kansas law, of course, as a limited liability partnership, an LLP. It wasn't a real sophisticated operation. It just basically had three lawyers, and they were providing legal services and getting paid for that. Now, you can see as a setup, this isn't a real complicated case. I mean, that's all they were doing was providing legal services and getting paid for it. It's difficult to say that that's passive income unless you're snoozing and billing people anyway for the time. That's a whole nother conversation. Maybe they were doing that. I don't know. That would have been a good defense for this case, but pretty bad for their license, right? They might take that away for that. Anyway, it was basically no more, there's some different classes within this, and they all said they were both general managing partner and investment partner. So they papered it up, right, to be a limited liability partnership, and they really tried to make it look for all intents and purposes that it was a division between they were doing some services and they were getting some passive income. This is really common, right, the bifurcation or allotment approach. All right, so they were doing this in 2004 and 2005. The IRS said, no, I completely disagree with this. All of this income, right, should be considered net earnings from self-employment and hence subject to SECA taxes. They went to court. Again, imagine this. Lawyers disagreeing and deciding to say, we're going to take the gloves off and go to court, but that's what happened. It was, at least they got their legal fees on the cheap, right? Bam. Wow, terrible. And I think that they did. All right. Again, I don't make these jokes all the time, but just whatever occurs to me up here, I go with it. Some of you, I can't get a laugh out of, but I'm going to by the end. All right. So anyway, they have their litigation about this. We could go all through it. You can imagine what their arguments are. Just kind of what I hinted at. Hey, we formed as a limited liability partnership under Kansas law, right? Under Kansas law, we say we're limited partners. Look at all of our agreements, right? We say we have limited partnerships, general partner, all of the normal arguments you would suspect. And oh, by the way, hey guys, what's the guidance, right? There are no regs out here that are issued regulations. All you have is this law from 1977, and we are comporting with the law, right? I mean, it's not that far-fetched. If you don't like what we're doing, change the damn rules, right? That's the basic argument of a lot of lawyers, and we use it ourselves. Anyway, the tax court, unfortunately, disagreed with that. And again, it's important because it's the first precedential case. The tax court looked back at that legislative history that I mentioned way back, and I don't even know what year it was when they were talking about the cheating involving Social Security. And they said, no. Right? This exception was really set up when we're looking at earnings which are basically of an investment nature. That's what they said, hearkening back to legislative history decades and decades earlier. And they said what we've all pointed out, guys, let's see what's happening here. Number one, you're deriving basically all of your revenue, lawyers, from providing legal services. Number two, there's not a lot of skin in this game. You guys have very little capital that you put into your organization. I don't know why that is. We put in a ton of capital in our organization. But anyway, they didn't put much into theirs. And again, the distributive shares were not in the earnings that were basically of an investment nature. It wasn't a very sophisticated analysis, but it did set the tone in 2011. Okay, there we were in 2011. Well, that's rather deflating for all of us, right? This is like an emotional whirlwind, isn't it? 2011, the IRS comes out and the IRS says, okay, we just beat you up on Rankemeyer. And they're talking to taxpayers in general. Again, these are my words, not the IRS's words. I don't think you're going to hear them talking like this or writing like this, thinking like this perhaps, but not talking like this. But an attorney from the national office came out at an ABA, American Bar Association meeting in Washington, D.C., and they said, okay, we recognize what happened in Rankemeyer. It was a TC opinion. We're going to beat you over the head with this. But notwithstanding all of that, right, if you follow the second proposed regulations, right, we are not going to challenge you. It said, quote unquote, you quote unquote could rely on the second proposed regulations. Again, people were now more excited. They were thinking, oh no, the IRS is going to beat us over the head on every single case. And the IRS came out and said, no, we like the guidance that we came out with years ago. It's not finalized, but let's stick with it. If you do, we will as well. So that was in 2011. Oh, actually, let me read the quote. It goes on a little bit more because it'll be perfect for setting the tone. It says, IRS officials have said many, many times that the IRS will not challenge positions taken by partners who rely on the second proposed regulations to determine whether a partner's earnings are subject to self-employment tax. That's fairly definitive coming from an IRS national office attorney at an ABA meeting in Washington, D.C. Now, of course, that person, I'm sure, no longer works for the organization. I don't know. But anyway, that was back in 2011, and I'd have to look up. Actually, I have noted here who said it, but it's neither here nor there. Again, putting it down on my list. Right? What else are we looking for? Guys, someone is responsible for looking up why actuarial scientists are stuck on that list. That is the brain teaser of the day. And I heard, I mean, it's not official, but I heard that if you do figure this out by tonight, they're going to give one of those polos out.
As soon as they print them.
Yeah, you don't have to bring in a new member. If you bring in a new member, or you find out the real answer about actuarial science, you get a polo.
What if you bring in a new member who has the answer?
Oh my! Well, fellas, I defer to, I don't know who it is. Jim, Emily, you guys are in charge of that. I don't want to write a check with my mouth, right? I can't. I'm not responsible for the polos. But all right, that was in 2011. We're excited. Again, we're going up and down, up and down. However, that's the sound effects. That's like thunder. That's building the tension.
Break out a little golf throat.
2018, the IRS says, you know what, guys, we gave you a lot of latitude here. We didn't beat you over the head with Rankemeyer. We said in 2011, as long as you respect the second proposed regulations, we are not going to come and harass you. The IRS figured out, you know what? No one's listening to us. No one is listening to us. They are continuing on in the same way that they always have. So in 2018, the IRS starts a compliance campaign, the dreaded double C. Most people, taxpayers, when they hear compliance campaign, they are, first off, they ask, what the hell does that mean? And then they're downtrodden when they figure that out. And then when I hear compliance campaign, well, I was thinking more like being gainfully employed constantly and growing, but perhaps, yes. And I had to say, look, it's not my issue. What can I tell you? The IRS has said they're going to attack every single one of these, right? I'm just here to help. But yes, it is true, right? It's down, it's bad for the taxpayers, it's bad, but for us, generally speaking, it means there is going to be huge amounts of fighting about this, because not only are they going to audit everybody because it's a predetermined conclusion, they're always going to come to this. And secondly, now that I kind of say this, again, I don't know if you guys know this or not, when they have a compliance campaign, and usually they have issues that are defined as designated for litigation, and you should always ask this in these, if you have, and the greatest example that I have to date is the conservation easements. And I know I always mention it because we have so many cases in this area, and they had the same thing, right? Making listed transactions, having a compliance campaign. And once that occurred, it made it very clear that the end result of the audit was going to be the same every single time, irrespective of whether you did the audit, the interview with the tax, with the IRS, whether you allowed or didn't allow a site visit to the property, whether you gave them 1,000 pages of documents or 2 documents, it was going to be the same conclusion. In addition, and this applies here, in addition, when you go to the appeals office as well, the appeals officers will say, I don't have any, usually I have full discretion to settle cases. They will say, because it's part of the compliance campaign, I don't have any discretion to settle this other than on these particular terms, which means, by and large, it's moot, right, to go to the IRS appeals office. And then thirdly, when you get to the level of the tax court, and then for those of you who have talked with me, we talk about the reality is, although we will happily go litigate cases, we do everything possible to settle the cases for the clients before that occurs. And there are many ways to go about doing that. And the IRS will say, sorry, these are quote unquote designated for litigation. And from the national office, I've got to go litigate this case no matter what. Even if you show them that the likelihood of them losing is very high for these 10 reasons, they will say the IRS national office has decided that we are going to create rules through litigation, not through settlements, regulations, etc. So when I say it's a compliance campaign, it has a lot of ramifications, and I just wanted to clarify for everybody what this really means. Of course, I was joking, maybe not, about more work, but there's a lot more work than you would ever expect simply because of this classification. All right, with that said, it was in 2008, and what did the IRS say? According to the IRS, some entities that are treated as partnerships are classifying all members as limited partners. That's made me think. Thereby avoiding SECA taxes on partnership distributions altogether. So that's pretty egregious, right? Everyone being treated as limited partners and all income avoiding SECA taxes. We can all agree that might be a little extreme. Yes? Okay, all right. I just want to check the temperature out there. Like, who am I talking to? Like, oh no, I never pay SECA. Anyway, that's pretty extreme. And then they say other partnerships are taking a more moderate approach, arguing that only a portion of the distribution should be subject to SECA taxes, okay? And they accomplish this, as you would suspect, by labeling some amounts as wages or guaranteed payments, right? And you can imagine that's going to be if there's 100%, how much do you think is going to be treated as? I don't do returns. I don't know what it would be. So you guys are thinking if you guys were thinking on the inside, or you talk to partners, they're thinking.
They took the S corporation model.
Yeah.
Yeah, 20, okay. I don't even know your answer. So does that sound consistent with everybody? They're thinking 25% might be enough to get the IRS to look elsewhere?
Something being better than nothing.
Yeah. Okay. I don't know. Again, I don't know what the inside is. I don't do returns. I'm just kind of curious to see what's happening out there in the real world. So anyway, a lot of people were doing that. I call that the allocation method, the bifurcation method, et cetera. And that is, of course, better than having no one paying SECA taxes, right? So anyway, that's what it was. And here it is. I want to read to you summarizing here. The IRS has summarized the problem in 2018 when it blew out this compliance campaign. Quote, partners report income passed through from their partnerships. Unless an individual partner qualifies as a limited partner for SECA purposes, that distributed share is subject to such taxes. Some individual partners, including, and they didn't say lawyers, but I know they were thinking it, including service partners and service partnerships organized as state law LLCs, LPs, and LLLPs, have inappropriately claimed to qualify as limited partners, not subject to the SECA tax. Well, there you have it in a nutshell. So that was in 2018. Now, what happens next? That is true. And it's also, so I know you thought I was going to jump years because you're like, oh no, is this road over? Well, no, we have to go now annually. 2019, the IRS said, and this is again, not mocking the IRS, but just because they announce a compliance campaign, they've got to train people to implement and execute the compliance campaign, right? The revenue agent is the first line of defense or offense, depending on how you look at it, right? They're not necessarily trained in the intricacies of self-employment taxes. I mean, they don't know. They didn't come to the presentation. They didn't see the long road. They didn't read any of that, but they need to know it, right, to do these kind of cases. So they came out with what's called the concept unit, right? Do you guys read these things when they come out from the IRS? Okay, good. They have like, is it IPU, internal practice unit? I have all of these websites on my, I'm taking a show of hands of how nerdy everybody is in this room and like make a comparison, but I do every day, even at my stage doing this forever. I get all the, the services, the tax analyst, the checkpoint, the JD super. I look at that every single day, the first day when I get up, as embarrassing as that is. And then I have on my internet, I have not my favorites of, well, I'm sure some favorites we're not going to talk about here, but the business related ones I look at, and it's all like, did they come out with any new concept units, practice units, regulate? I look at each one of those on a daily basis because I need to for the clients, and I need to for my interest in terms of writing. And then I also look at not only the cases that were issued by the courts. What time does the tax court issue the 3 o'clock? That we have a clock that goes off every day at 3:01, and we look every single day at what it is. And on top of that, we have the services that show every time that there's a case that's filed in district court anywhere in the country that involves taxes, because they have to label the number, we get that immediately. So we know, right, a long time before anybody else sees it, cases that are going through the courts that are going to be interesting or effective. And if anybody wants to know how you do that, I mean, there's a cost associated with it, but let me know. I'll be happy to tell you how you do that. So anyway, we look through this stuff all the time. And what the IRS issue here is called a concept unit. And I think there's other ones called practice units or things like that, but they're very good because it really shows you if you're going to have audits with the IRS. I mean, that's the playbook that an inexperienced person's going to use. Oh, an audit technique guide. Those are great, right? The ATGs. Everyone, please tell me everyone uses the ATGs. I mean, they're all out there. They are fantastic. You should definitely use those in terms of any case. And we even do at this stage. Anyway, getting back to the concept unit. Why do I bring it up? Well, I guess it gives an opportunity to talk about what we just did. But more importantly, let me rip from the CU here several things that it said that are important. First off, it acknowledged to all of the revenue agents that section 1402A13, the exception, does not define the term limited partner, right? Neither does the law. So they basically say, guys, it is what it is. There are no final regulations, and the IRS personnel must rely solely on legislative history back in 1977 when they were trying to stop people from getting Social Security, and case law in making determinations. And as we discussed, up until 2019, how many cases that had precedential value existed? One. This attention level, we got a high attention span in the room today. Well, yeah, no, it's good. I'm glad you are. So that's it. Guys, think about it. They told the revenue agents, hey guys, you're going to go out and do all these cases, and we have all these proposed regs, all of these proposals from people, whatever else. But the only thing that you're going to look at is the legislative history, which says if it's not basically money coming back of an investment nature, you're hit with SECA. And oh, by the way, look at Rankemeyer, which says, oh, you're hit with SECA. Again, I don't want to say they're going to come to a different conclusion, but that's pretty hard when they said their only guidance are those two things. Number two, it goes on and says, hey, this concept unit applies to all of these types of entities. And of course, this is, I love all of these types, the LPs, LLCs, LLLPs, and they go on and on. There's more by 2019 than there were the first time the second proposed regs came out in 1997. Third, the concept unit instructs, demands IRS personnel to ignore. They specifically, I don't see you saying they say they're not relevant. Anyway, ignore the long list of decisions that were favorable to taxpayers in the context of limited partners and passive activity loss limitation rules under section 469. So if you guys go out there and do these kind of cases, there's just, I have probably, no exaggeration, 3 or 4 binders full of the start of time of 469 until where it is today, everything in legislative history, whatever else. It's massive. They told the revenue agents, guys, scrap it. Don't look at it. Don't whatever else. If people like me try to argue and say, wait a minute, right? Your rule is you say, look at the second proposed regulations. The third tier of that says, if I don't work more than 500 hours, that's the rule. That's the same rule we have in material participation. So let me just show you some cases where they work on this. Nope, not going to do it. Not going to listen to it. I know it's like the cone of shame with the dog, but maybe. I would say the blinders with the horse. I don't know what a better illustration is. Point is, They will not use it. They will not accept it from you if you argue it or anything else, no matter how valid it may be or how on point. They will not argue. They've been told not to listen to that. They said, quote, the material participation rules under Section 469 have, quote, no bearing on whether an individual partner may be subject to self-employment taxes under 1402. Again, same organization, same standards, writing the rules, but they said in one context, use it, in the other context, ignore it like it didn't happen. You know my opinion on this, obviously, from that editorializing. All right, number four, and I think this is probably the most important, the concept unit. It's hard to believe, after what I just told you, the concept unit said it goes on for 3 pages to discuss the second proposed regulations, which of course were never finalized. And interestingly, the IRS has decided to overlook the incomplete status, and they said the following: hey guys, the second proposed regulations are not final, right? They may not be enforced on taxpayers, or I guess the other way around. Instead, the applicable analysis is the statutory language, right, and the exception itself, the legislative history and case law. However, and this is a big however, to make it, if you guys look at the outline, I actually put it in italics, so we wouldn't look over. It says, however, taxpayers may rely on the second proposed regulations. In other words, the IRS will respect a partner's status as a limited partner if the partner qualifies as a limited partner under the second proposed regulations. So I scratch my head and I say to myself, wait a minute, we just all went through the second proposed regulations, right? And one of the major ones was if you work less than 500 hours, you can be considered a limited partner. Or the opposite is if you work more than 500, you're going to be presumed not to be a limited partner. So they said on one hand, you can rely on that. Right above it, they say, oh, by the way, you can't look at any cases dealing with 469. So I'm very confused about the internal inconsistency. Maybe I'm the only one that saw that, but it's frustrating to me. I'm not as frustrated as the actuarial scientist, but I'm frustrated.
If you argue it's 469, it's no good, but if you argue it in the context of the second proposed regulations,
It's okay.
You're all right.
Yes. That's crazy, huh? All right. Welcome to my world. This is why people always get mad at us for, I'm like, look, I'm not exacerbating the situation. It couldn't be any more exacerbated than it is today, but that's what happened in 2019. And if you are frustrated perhaps with revenue agents and saying, guys, why? It's important to understand where they're coming from as well, because if they have to follow the concept unit, they can't go out on their own or they wouldn't have that job. All right, we're still in 2019, and now I'm only looking one last half page to the end of this long road till we get to the current cases. In 2019, interesting, and this is the same year that they came out with the concept unit, what happened is that the IRS took off their list of priority issues, finalizing the regulations. So from 1997, when they came out with the second proposed regulations, I don't know, again, you guys are really getting a glimpse into the internal Hale, but I look at every year they come out with the priority guidance plan. You guys, like the first of the year is fantastic for us. You get the revenue procedure talking about what they'll issue private letter rulings on, what they won't, all of those neat things. I read those and they come out with a priority guidance plan. And that's basically says, hey, what is the IRS trying to accomplish during the year? Like a wish list. Do you guys read the priority guidance plan? Okay, I recommend that you should, because if you're talking with clients and they're like, well, okay, we have a fight about this. Is there going to be any changes that will affect me or what? It's really good to kind of see that. Again, it doesn't mean that they accomplish this. In fact, the second proposed regulations, or basically the regulations for limited partner, had been on that list from 1997 until 2019. That's sinking in, isn't it? That was a priority from 1997. Yeah. But it was the point is they still had someone assigned to it and they were still thinking about doing the regulations up this entire time. And then in 2019, which I felt was really symbolic, that when they came out and they said compliance campaign is coming on, she was so mad she just stormed out of here. She's like, I can't take the injustice of what's happening. It wasn't boredom. It wasn't disinterest in this presentation. It was indignation at the IRS. But anyway, in 2018, they had the compliance campaign. 2019, they said, hey, soldiers, here are your marching orders. In 2019, they said, we're not even going to pretend like we're going to do the regulations anymore. Hell with that. Again, my words, not the IRS's. That was really interesting to me, the fact that it disappeared. And again, not that I'm somehow smart, but I noticed this and, of course, wrote all about it. I thought it would get some, again, massive indignation, but no one cared. That's fine. All right. Two more things, and then we are to where we are today. In 2021, this was under the former presidential administration, right? And for those of you guys who attended the presentation yesterday, I probably, bored you to death talking about all these different colored books that are out there all the time. The blue book meaning the legislative history, the green book being the revenue proposals. What is the one about budgeting? The purple book, I think. I don't know. They have all different colors, and honestly, we have a little. I hate to admit this, but I have like a little chart in the office, right? It's like a little kid graph, like a legend, like the color and then what it is, whatever, because it's hard, because it's confusing. Anyway, the green book is when the presidential administration at the time comes out and says, hey, here's Congress, what we would really like you to accomplish. We are the executive branch, not the legislative branch, but if you're taking any advice from us, we'd really like you to go this way. So they're signaling what they wanted to be done. And I think it's interesting because they acknowledged at that time how inconsistent and chaotic the situation was. I mean, that doesn't take a mastermind to say. If I figured it out, anyone can figure this out. And they said, we need to quote unquote rationalize the rules regarding SECA taxes. There's not enough guidance. And so what they said was, interestingly, remember I said there were several proposals that we went through before? The material participation, reasonable compensation, and safe harbor. What do you think Biden and his crew picked? No, don't look at the outline. Anyone who's not looking at the outline, what do you think Biden picked of those three? He did. Oh, you're looking at the slides. All right. See, that's why I need the rolling out. And anyway, he picked the material participation. I didn't realize I had it up there. Anyway, that was that was not a good reveal, right? It was already up there the whole time. Note to self, check with 11-year-old daughter, get the points. I will do that. Anyway, he picked the material participation standard, which again shows, wow, okay. And frankly, no one's asking me, but that seems to me inherently logical just because we've got so much case law and rules developed over time. They've worked out the kinks. Let's just go with that. Anyway, they have not been accepting that. In fact, so much so, and this is to the disappointment of many people, the end of this long road until we get to the now current cases. The IRS said now in 2021, you remember in 2003, they came out and said, hey, go with the proposed regs. I'm sorry they didn't get finalized because Congress was being stubborn, but you can still rely on the second proposed regulations. Then again, in big statements in 2011, they said, hey, we know we just beat you up on Rankemeyer, but we're not going to lord that over you. Still, just follow the second proposed regulations, right? And you'll be okay. Jump forward to 2019. After the compliance campaign, they came out with a concept unit and said to all of the revenue agents, hey guys, it's okay. Just respect the second proposed regulation. So we see a message happening. Here's what happens in 2021. The IRS takes a turn and it says, this is again from the national office, at a big conference, they said, oh, by the way, heck with all that. We're just going to keep litigating all these cases and create law through litigation because we have been, quote unquote, fairly successful in this area. Now, again, fairly successful at that time was one case called Rankemeyer. Okay, so you can see, and again, I say this and people say, oh, I have to hear about a long journey. Why? Well, I want you to understand the journey because it's really important as we see the legal arguments going on today, how we got here. And this is really unique, right? I don't see situations where we've got government in action for 50 years, all these different possible solutions. We've got non-precedential holdings. We've got mixed messages coming in from the IRS itself. We've got a completely abandonment of trying to correct the rules saying, hey, it's gloves off. We can't get this worked out. Congress won't act, so we're just going to go clog up the courts with all of these all the time. And that's why we have so much litigation. So I said, I joke around and try to make it entertaining, but this is really why it is where it is today. And so when the IRS comes to you all and, you're advising clients, I don't advise on the front end, I only do the back end, right? But when they come to you and say, oh, I've got the same situation, which you guys have acknowledged happens regularly. Is that fair to say? Regularly with clients? And they say, okay, first off, it'd be important if you actually, I'm not saying you don't, but if you had a broader now understanding of the rules, which you're welcome to take the outline and look at it any time and say, hey, here's how we got here. And then secondly, you can say, here are the kind of what people do, right? Is it either you call yourselves fully limited partners and roll the dice and maybe they'll audit you, maybe they're not. It's inappropriate for us to talk about probability of audit as a factor, as you guys know. So I don't talk about that, but there's a fly up here. He wanted to attend this presentation. Maybe it's my cologne. I don't know. I like the gnat up here. But anyway, that as a reality, or do they want to do the bifurcation allocation method, and what does that mean, and whatever else? But anyway, it's important for you all to know where we are, how we got here, and what you could possibly see. So that's the purpose of doing the whole long road to where we are. And you guys know, and as they were yelling out the door, yelling out Soroban and all these cases, there are, I think I updated this right before I came here today. So we're going to look at how many cases there are. Oh my. I'm going to just tell you before we get to it. This isn't on the slide, I don't even think. Currently that I have on my tracker that are pending in tax court right now are 8 cases, big cases, and those are not even the ones percolating through the audit. And we have a bunch on our desk that are percolating through the audit, or they're in appeals. Now you guys may say, appeals? You just said a minute ago, Hale, that you weren't going to go anywhere in appeals, right? This is a compliance campaign. You're not going to get any justice. Why would you have cases in appeals? Why would Hale have cases in appeals?
Because it needs to be ruled against in order to go up to the next.
Yeah, well, you could. No, but you can skip altogether. We skip appeals. Oh, that's a great point. You can. Sometimes you want to have an appellate for strategic, like, can you get your fees back? Did you exhaust your administrative remedies? Absolutely true. So again, I'm a little bit going off the script, but I like this because I know you guys do this kind of work. If I say, hey, before I told you this is a compliance campaign, that means that we're going to get no love at the audit level and no love at the, again, I'm just talking casually, at the appellate level, and we know that. So if I just told you, and we're going to go through the cases, why would I make up a number, probably 15 to 20 of these cases, sitting with the IRS appeals office right now? Right, I'm going to tell you a few different reasons. Again, this isn't part of it, but just important to kind of talk about it from a strategic standpoint. Number one, absolutely, the point that you make is a lot of times if we're setting up the stage to hopefully get a win, or if we get a win, not only get the win, but get to recoup our fees, we would have had to exhaust our administrative remedies, and that means that we tried to do an appeal even though we thought it was bunk, right? That may be a reason. Number two, and this is probably a good reason, the clients are going to say, and we represent huge clients to small clients, and that's a great thing about a firm our size. We can do big to small or whatever. Some of our smaller clients say, hey, this is wonderful. This is really a big issue for us, but I don't have the money to go litigate this case. I just don't have the cash to do that. So I'm going to sit where I am, right, and hope for some kind of resolution up top, and then I'm going to benefit from that. And then third, and kind of related to that, even people that do have the cash to fight this out, right, they say, well, wait a minute, Hale, you're going to go through the fact that there are 8 major cases sitting in the tax court. There are 3 major cases sitting at different courts of appeals. The Second Circuit, the Fifth Circuit, the First Circuit, you're going to have all these courts of appeals ruling on this issue. And if it's favorable or split, fantastic, keep fighting. If they all rule against you, cut your losses, right, and move on. So when people say, if you're listening, you'd say, well, Hale, what you said was inconsistent. Why would you have cases and appeals when you said you don't give extensions and you're not going to get anywhere? There are strategic reasons why we would go to appeals. And I'm glad, well, hopefully it's nice to talk with a group of, colleagues that don't understand this about why we would do these kind of things. So anyway, I'm getting a little off the path here. I guess I'm so excited about this long road and ending the long road. That's where we are. And then we're going to get to some of the, no, I'm not doing the summary. I've already done that. All right. So that's where we are today. And I will get to the current cases. And again, I'm not going to go through all 8 pending cases and all 11 cases on appeals. Why? Because at the end of the day, they're the same. Right? I mean, they're not, right? You're going to look at them and factually, you're going to say, I mean, I see them and it's, simplistically, you can understand, okay, this is just one entity or whatever else, but we see the structures where you got multi-tier structures and you got a general manager, which is a partnership, which is owned by 2 LLC, which are owned by, right? It's amazingly complex. And at what level do you look at who's being active and who's being this? And it's all different states where they form the entities, all different levels of activity. So factually, it's very different, all of the cases, right? But the underlying legal issue, right, is the same. And so if it comes down to a legal issue and they say, again, this is just more of a conversation, I think it's interesting. If they say, wait, going back to 1997, when they changed from the first proposed regs to the second, they said what? It's a functional test. It's a functional approach. We know there's going to be different labels. We know that people are going to form entities to conform to those labels. Who wouldn't, right? That's advantageous to you. Right? But they're going to say those labels don't rule, particularly at state law. So we need to figure out what is going on inside each particular partnership. So it's going to be fact-driven. But at the core, at the end of the day, if they make broad rulings that apply to everybody, broad rulings such as, and they already started doing this, state law labels don't matter. Material participation rules don't have any applicability. If they start making those kind of grandiose rulings that are negative toward you, you're going to know. And on the other side as well. So if it's factual, we're not discouraged because every case is different. If it's a big legal issue applicable to everybody, we know what's going on and we haven't had those yet. So this is a still very, very active and undecided issue. And again, what's interesting to me, perhaps, again, getting a little ahead of it, is even if we do get these cases coming down from, again, there's 3 different courts of appeals out there talking about this. And they're all proud people and they come up with their own opinions and they don't call each other up and say, hey, for the good of the country, let's just try to work this out and all kind of hold the same way. No, they do not, right? They all have different rulings. They all have different opinions. They may decide X, it may create chaos again. And so if they don't have conformity, we're going to continue on for a long period of time. And what I find particularly interesting is not only the ongoing cases for probably the next half decade, at least. If you're asking Hale and what's going to be in our practice, probably a half decade at least we'll have these cases sitting in there. What's going to happen afterward, right? Those are still going to be court rulings, but you would think at some point the IRS is going to say, okay, right, we've got this hodgepodge out there as well. We are now finally going to do some regulations. So I hope once it normalizes up there, they do put some regulations out there, but I don't know. We might have more slides in the long road. What does they call it? The long road to chaos. There might be some additional slides if we do this presentation. If I come do this presentation again, I'm gonna make an agreement with you guys. If you guys have seen up until 2021, you're just gonna raise your hand, right? And then you're just gonna go out and have coffee until we get to 2020. Yeah,
It'll be the long and winding.
it'll be something. But you'll say, hey, this get me up to date. I already remember. In fact, it was so impactful. I've been dreaming about this presentation I only wish we caught it on video so I could watch it again. Oh, I thought you were gonna ask a question, but yes, it is gotten out of hand. And that's why I call it chaos. So again, I joke around about it, but it is very chaotic from a legal standpoint because you guys don't have the guidance, and it's frustrating with your clients because if you don't have the guidance, how can you adequately advise yours? So I mentioned there's only one precedential case, and now this is just going to be more conversational. I said I'm going to try to end, hope you guys don't mind, about 10 o'clock, a few minutes early. And I can justify this because I talked fairly fast, so we got more information. But secondly, I do have to catch the plane back, and not that I don't love it here. It's very nice. It is very nice in all sincerity. I just have to be back, and I don't want to miss the plane. But I did mention that there are lots of different cases out there on this, non-precedential cases. Now, you guys, I don't know how you are, and I know I keep saying that as a big deal, but even if they're not precedential, you know that you utilize them, we utilize them, and the IRS utilizes these types of cases, right? And I'm referring to all types of guidance, whether it be private letter rulings, whether it be tax court summary opinions, TC memo opinions, chief counsel advisors, et cetera. There are lots out there, so there is guidance, and I'm going to go over some of those with you guys as well, because that's important. When you're still arguing at the lower level, it's important that you guys are going to cite those. So I don't want you to think when you go into your audits, well, I'd love you to say, hey, this is beyond my area. I'm going to call Hale and get him involved. Now that would be number one ideal. Do I think that's always going to happen? No, I do not. And you're going to work with your clients, and that's completely understandable. And when you do so, the whole point of this segment of the presentation is that you guys kind of have a thorough understanding of the guidance out there. This is almost all the major guidance, so you can utilize that in your favor. And also, when you see the examination reports from the IRS, you're also going to have a head start on what kind of cases they're citing against you because they're all right here. In closing, I'm trying to make this real easy for you guys. If these cases come up, just look at the darn outline. You're going to have what you need. All right? Good. Okay. Because again, just if they're good, they're favorable or unfavorable, it doesn't matter. You need to know what they are because the IRS is going to reuse them against you. For our purposes, I'm going to jump over, and again, I don't have it highlighted. I'm just going to pick out the ones that I think are the most kind of interesting for us here today. And of course, it's not going to be Rankemeyer. We've already spent time on that. We're already dissatisfied with that. And if you are looking at the outline and you may say, okay, well, where is Hale? What's he talking about? Again, it's not going to be now. It's going to be 6 months from now. It's going to be whatever, when one of these audits pops up and you're going to say, what did that guy say again? I'm just telling you, it's about I think it starts on page 23 of my outline of where I start going through all of the cases. Phyllis is saying, yes, you're not insane. Well, you're not insane when it comes to the pages. Yeah, absolutely. Anyway, I'm on 26 because I jumped up to Rankemeyer. And again, I'm looking for the ones that I really, really like. I'm trying to find the one who was the the franchise owner, because I thought that was very, very interesting. And there's also another one where the taxpayer actually wins. Okay. The one about the franchise owner, let's get to that. It is actually a chief counsel advice, and it starts on page 29. I don't need to read the number of the chief counsel advice. No one will remember that. It doesn't matter. Just remember it's on this particular page. And you guys, are you guys familiar with how a chief counsel advice comes up? Yeah. Okay. Well, good. Yeah. Well, we got some head nodding. Yes. Some no. The basic idea here is this is not a court case, whatever else. Basically, you've got someone out in the field, whether it be a revenue agent, sometimes even the IRS turns it, but they do it as far as legal. They have a question. They basically want some guidance before they go out issuing the report or otherwise and say, hey, national office, what saith you about X? Right. So this is pretty insightful in terms of what the IRS's position is. So in this particular one, and again, it's a little bit different than the ones we've seen before, right? We've already picked our fair share on the lawyers. Or you guys need more? You're like, no, we need to pick on the lawyers more. We can later. There's plenty of cases picking on lawyers out here. And you know, I can't even say in their defense, well, they continue to take the position that they're limited partners, so I'm not really surprised that they're getting beat up quite a bit. I'm waiting for that golden case with the actuarial scientist, and then I'm going to be a content man. Anyway, the chief counsel advice, you've got a guy who owns a whole bunch. He's got an LLC, and he owns and operates a whole chain of restaurants. I like to make it relatable, so I call it Subways. Is it Subways? No, it's not. All right. I'm sorry, do you guys prefer a different chain? We could do a different chain. All right, so we're going to go Subway. Okay, well, if you yell something out Tourette style in the middle of the presentation, I'll switch on the fly. We can use anything that you want during the presentation. But anyway, this guy owned a number of Subway restaurants. And of course, how is he getting his money? And this is important, right? He's selling sandwiches. Right? Or whatever they sell. What do they sell? Sandwiches and I'm sure cookies. And I don't know if they have any like supplementary services. I don't know what's going on in the Subway these days. But the point is they're selling product. That's important because what are the lawyers selling? Services. Significantly different, right? And usually it's the lawyers who's like sitting down, they're billing the hours and they're billing and saying, hey, pay me for these services. So the guy who's owning the Subways, you think he's making the sandwiches? Yeah, he's not making the sandwiches. So again, I'm kind of setting this up. You're like, oh, okay, this sounds a little bit different, right? Maybe we're onto something here, right? So I thought this case was particularly interesting. The IRS, not so much. Again, I'm sorry. I'm always rushed to the punchline, right? I know you guys were, this is going to be good. But anyway, let's get to the facts of the case. He said, so he's got a bunch of agreements between the franchisee, our guy, and the franchisor mandated that the franchisee personally devote full-time and best efforts to operating the restaurants. Well, that's going to be pretty hard considering he owns like 50, but anyway, maybe he's given full efforts dividing among 50 restaurants. I don't know, but it makes sense. And that's going to be a standard clause in any one of these agreements. Subway's not going to negotiate with you and say, okay, just dial it in. We don't care how much you're working on it. Similarly, the operating agreement for the LLC named the franchisee as all the big names, president, CEO, and manager, indicated that he's going to conduct all business affairs and granted him authority, of course, to make all major decisions on behalf of the entity. That makes all the sense in the world, right? He is the big cheese doing this. And that includes that he can go out and, borrow money on behalf of this, enter into contracts, oversee employees, handle correspondence, et cetera, et cetera, et cetera. Nothing surprising in there at all, standard language in the agreement. The LLC bifurcated the amounts going to this guy, right? And again, I think this is inherently logical. And it said, this is not a case. This is the chief counsel advice just going back and forth through IRS people. It says he treated certain amounts as guaranteed payments, right? Similar to the notion of reasonable compensation. Like he said, hey, I'm making a killing off of selling these hoagies, or what do they call it in this part of the country? Hoagers, subs, grinders, subs. Okay. Got to get the terminology correct. All right, subs. You have heard those, right? I mean, they do call them hoagies, and I don't know where that takes place. I didn't even know who was playing football yesterday and who rooted for which team. So I'm a little out of my element here. But anyway, subs. So he said, look, I'm going to get some guaranteed payments because I am providing some services, right? I am the CEO and an officer. And so that makes all the sense in the world. And I assume that in his division, he probably said, okay, what does an officer, president, or CEO make in these kind of situations? And I'm going to pay SECA taxes based on that. Then all the other amounts that were characterized to what was flowing up from all the other restaurants. And by the way, we're going to get to this. He treated that as not subject to SECA taxes, right? That was profits coming from the selling of sandwiches, from all the sweat of other people's brow, not his. All right, let's go on. In addressing this issue, the IRS pointed out a few different things, right? These are obvious things and nothing real surprising, right? Everything I've already said. He had sole authority over the LLC. The guy was the head cheese, right? The president, CEO, etc. Yes, he had several executive level employees. That's true, but he was the only active member in the overarching LLC, and he participated in the management. Again, I don't think those are particularly strong arguments or in any way impactful in what we have. The LLC, the taxpayer conceded, right? The legislative history back from 1977, we talked about it. Also said, hey, look, Rankenmeyer's out there. I get that. That was 5 years ago. That's absolutely true. However, franchisees are not like the guys you're talking about in Rankenmeyer. And Rankenmeyer, it's a law firm. Again, he lays it out pretty directly. But again, I kind of hinted at I don't hint at anything. I told you guys what the differences are. This is not a services, right? He's providing services as an overseer, as a business person of the operations, but he is not out at his 50 Subway operations slapping on mustard or mayo. Again, I don't know what they put on him up here, but they're putting some kind of condiment. He's not doing that. He said, look, it was distinct because the income I derived came from products, not services. I made significant capital contributions to the LLC. How did I get the franchise to begin with? How did I get the equipment? How did I get all these locations? He put tons of money. I'm sure he's leveraged up to the hilt to get this going. And the franchisee delegated significant management responsibilities to all kinds of executive level employees and managers at each and every store, right? Therefore, if you really look at it from a substance over form perspective, absolutely the bifurcation, right, would have been appropriate. That was his basic argument. You guys know how the IRS came out on this one, right? Again, I thought it was a very strong argument. This was not a case, so we don't have any court adjudication. And clearly, since it didn't go anywhere, I never saw it in the courts. This guy probably just either came to a settlement or conceded or moved on for whatever reason. I don't know. There's so many things behind the strategy, but the point is it didn't come up into litigation, so we don't have a ruling. But the IRS had said, in short, hey guys, this is an LLC. This is not a corporation. And these reasonable comp rules apply in the latter context, not in the former context. So I get it, what he's trying to do, but inappropriate. We're not using reasonable compensation standards here. And again, I find it somewhat ironic because the entire test that they've been talking about is the functional test. Don't look at what kind of entity it is. Don't worry about any of that. Let's look at the function. But when the function is favorable to the client, to the taxpayer, not to the IRS, they said, no, don't look at the function. Look at the form. Anyway, again, I'm not trying to pick on the IRS. I'm just pointing out for you all the inconsistencies and how it works in the tax dispute process. So anyway, if you have this, I think this ruling is negative, but I think that the fact situation is quite common, and I would recommend looking at this if it comes up for any of your clients. And I want to make sure that there's one more that I want to find for you all, and then I'll talk briefly about the cases. I said I want to make sure, and I'm going to say this because this is a rare one. Here it is, a rare one when the taxpayer wins. In this case, it's called Hardy versus Commissioner. It did go to trial in the tax court in 2017. And again, if you're following along in the outline, I'm on page 31. This is a scenario where you've got a plastic surgeon, falls into the healthcare fields, right? So he's going to be considered a service partner. And the IRS, of course, is going to say without a lot of thinking, well, you're a doctor, right? Therefore, everything you do is going to be considered services and it's going to be subject to SECA, right? That's pretty the basic thought process. Well, here it was different because this surgeon, like a lot of these guys do, he says, well, yeah, I'm out doing my surgery all the time. And then at some point in between I was going to make some comment about it. I don't know what he could be doing very valid plastic surgery. I don't know. But anyway, he decides, wait a minute, why am I paying these guys all the time to use, I'm using their medical facilities. I'm just the service guy, right? I'm just a high paid like pilot or tech, right? I'm coming in. I need to get some of that surgery money. So that's what he does. He and a bunch of other doctors get together and they say, I'm going to have a medical facility. I'm going to put a bunch of capital into it and I'm going to be able to use it when I do some of my surgeries. And so are you. And so are any of these other doctors that want to do it, right? So they go out and they set up an LLC. Doesn't matter what. Whoa. I didn't realize today it's in Montana. He's probably driving around. Probably not. Yeah, not a Lamborghini because it's too cold and snowy up there. But I envision it. Maybe he's driving like a fancy, what is he driving? Range Rover or a Rivian or I don't know. Okay, what would you have? We can all imagine. We can all, dream. Anyway, it's called Missoula Bone and Joint Surgery Center. Anyway, he sets this all up, right? And again, he's not responsible for the day. I can't imagine a plastic surgeon being involved in the day-to-day operations of his surgical center, right? I mean, he provided some basic stuff. He doesn't provide the personnel. People are working the front office, whatever else. He does the stuff. He's got his anesthesiologist and he's got his, right, that's it. And he goes around and does the surgeries in many different places. He does that on his tax return accordingly. He says, yeah, for all the money I'm making being a surgeon, and I've got my own LLC for being a surgeon, I put that through and I pay my SECA taxes. However, when it comes to all the money flowing to me from the LLC, the medical facility, no way, right? I'm not paying SECA taxes on that. The IRS, of course, disagreed and got back to the most simplistic and said, you're a plastic surgeon, I don't like it, you're making gazillions of dollars a year. No, they didn't say this in the pleadings. I'm just guessing they said that. They didn't like it, but they made him go all the way to tax court about this. And this is, by the way, this was before the compliance campaign and before the concept unit. And then at the end of the day, the court looked at it and they held in favor of the taxpayer. And he said, look, as we pointed out, first off, the taxpayer was just an investor in that LLC. Number two, he only used that facility about 10% of the time. He was not involved in the day-to-day business operation of the facility. And the partners, the patients, pardon me, when they paid, they wrote separate checks, apparently, or the insurance. Well, you don't pay, by the way, you don't pay insurance for plastic surgery. So I guess that's why it makes sense now. The patients paid a separate check to the LLC for the surgical facility and a separate one to him for his services. So even in paper, they didn't even have to allocate it. It was right there. And the court said, no, IRS, I'm sorry, you lose on that particular one. So again, if you have these kind of cases, Hardy v. Commissioner is very favorable to taxpayers. Please look it up. And also what I find is interesting is in doing this, you know what the tax court looked at as one part of their analysis? The tax court said, boom, now you're getting it, 469. The tax court said, determine the taxpayer did not materially participate in the activities of the surgical facility such that the income flowing to him was passive for purposes of 469. So they're looking at it from two different ways. So the tax court even looked at it under the rules of 469 and material participation, even though the IRS says don't look at those, they don't exist. They couldn't convince the tax court that they couldn't do so, right? That's their rules, not the tax court rules. So again, the case is great for a couple of different reasons. One, because it makes us chuckle about the luxury cars and that's my favorite for that reason, that we can chuckle about the luxury car. Yeah. No, yeah, I don't think he wants to pay our taxes down there. Anyway, the point is that makes me chuckle. Secondly, it's a great case for the overall ruling. And third, it's good because the tax court itself looks at 469, even though the IRS tries to prevent us from doing so. The IRS does not mandate what the tax court does. Anyway, those are some of the cases. We're at 10 o'clock. Let me get to what and then I have a whole bunch starting on page 33 of the outline and going on. You're going to be so excited. This is all the stuff we're not talking about. This is going on in literally to page 50. I know a lot of material, a lot of substance there, but these are all the cases where I'm kind of summarizing what they did with the material participation rules, specifically in kind of the same standards, right? In the evolution in that area and how quickly the IRS has acted, changed the regulations, et cetera. Why do I include it? I include it because just because the IRS says don't look at 469 for these cases, that's not what necessarily the tax court says. And I wanted you guys to have the ammunition in case you wanted to make those arguments. So that's why that's there. The last point I want to make before departing and going back to Atlanta is I wanted to bring to your attention all of the cases that are currently out there. I've mentioned it several times. It's starting on page 50 of the outline. If you're going to look at this, and it's relatively short, I mean, by Hale standards. 50, it goes only 8 pages, right? And so what I do is I talk about, there's 3 major cases that have gone through the tax court already. I'll simply mention them to you so you know. It's one called Serious Solutions. And I think this is probably the smallest one in terms of how much money we have at stake. The IRS only wants to charge SECA taxes on about $5.6 million. Right, this is the smallest one of the cases. And again, that's just 1 or 2 years. You know, the ruling on that case is going to be determinative for later years as well, right? They pick up 16 and 17 or 20 and 21. And by the time this litigation is done, you've continued to work the same. You've still taken the same position about SECA for the next 5 years. So there's a lot more at stake than simply the numbers that we have here. Anyway, they go back and forth, and there's a lot of fighting in the court, both by litigation and by filing motions for summary judgment. So the courts really lay out both the positions of the IRS. and by the taxpayers. And again, why do I have this here? Because a lot of, if you look between all three cases, I don't think one case is comprehensive in terms of the best arguments that could be raised against the IRS. But if you look at them as a whole, and they're raised by different law firms, I think they do a pretty good job. Not to mention the long road stuff. You'd really have like a comprehensive set of arguments for the IRS. So that was serious. The second case was called Soraban Capital Partners, which is what Brad was yelling about as it was like he's being dragged out by a doorman, right? Out the door, yelling out Soraban. And then the last one is called Denim Capital. So those are the three major cases, again, that have gone through tax court that are now at different courts of appeals. And if you're interested in following any of these cases, if you look at page 58 of the outline, right before I came here, I updated every case that's already in the tax court, not in appeals, not in audit, that have this exact same issue. And I've listed all 8 right there. So if you're interested in following those, you could just put those in to come some kind of reminder or tickler you have and get popped up every time a case comes up. Or you could just send me an email and say, hey, Hale, send me the articles about SECA. And that would probably be easiest because then I'll do the work and send them to you. So anyway, but if you want to do the work, go ahead. By all means, do that. I'm going to do it anyway. So if you want to benefit, great. And with that, I will leave you. Thank you very much for having me. I appreciate it.